Hello everyone. I hope you all are safe and in good health. It is a pleasure to welcome all the participants to our webinar on ESOPs, Employee Retention Tool, Legal, FEMA, Companies Act and Tax Issues. To take us through this topic, we have with us our first panelist, Mr. Yatin Narang, who is a senior member of the firm and specializes in mergers and acquisitions, restructuring of business, asset and share purchase deals, takeovers, intellectual property, joint ventures, and strategic alliances, structuring of complex investments, private equity, employment, equity compensation, and general corporate advisory. Mr. Narang has experience of more than 12 years. He has advised many multinational companies and Indian corporates, including various startup and emerging growth businesses. We welcome you, Mr. Narang.
Thank you.
Our second panelist is Ms. Priyanka Jain, who is a chartered accountant and also a qualified lawyer. She is handling the direct tax practice of our Mumbai office. She regularly represents income tax litigation matters before various income tax authorities, Income Tax Appellate Tribunal, and the High Court, and has successfully argued several domestic and international tax matters. She is also adept at providing effective solutions to various contemporary corporate tax issues. We welcome you, ma'am. My name is Simran Gupta. I am an associate at the corporate practice of Vaish Mumbai office and a company secretary. So before moving further, I would like to inform the participants that they are on mute by default. However, if they have any questions, they can post the same in the questions tab on the control panel of the GoToWebinar platform. So without much ado, I would now like to invite Mr. Narang to share his inputs on this topic. Over to you, sir.
Thank you, Simran. I hope I'm audible.
Yes, you're audible.
Yeah. Good evening, everyone. Hope your family and you are keeping safe. In today's knowledge sharing session, we would be dealing in detail about the share-based compensation schemes. Simran and I would take you through the relevant provisions of Companies Act 2013, Companies Share Capital and Debenture Rules 2014, SEBI Share-Based Employee Benefit Regulations 2014, read with SEBI Circular dated June 16, 2015, SEBI Issue of Capital and Disclosure Requirements Regulation 2018, SEBI Prohibition of Insider Trading Regulations 2015, Foreign Exchange Management Act and the rules relating to ESOPs. And Priyanka would be dealing with the Income Tax Act relating to ESOPs. A world famous scientist and a great thinker, Mr. Albert Einstein, said, "Everything should be made as simple as possible, but no simpler." With this adage in mind, today we would try to cover various regulatory aspects of share-based compensation scheme and try to make it as simple as possible for you. Human resource. Human resource is the most fundamental and valuable resource in an organization. Therefore, it is not surprising to see that most enterprises spend considerable time, money, and effort to develop a robust HR department to cater to employees' compensatory and non-compensatory needs. Non-compensatory elements would include well-being of an employee, both mental and physical, recognition and development, motivated work environment, work-life balances, and such other soft aspects of life. The compensatory bucket takes care of the financial expectations, the base pay, the allowances, benefits, short-term incentives, and long-term incentives. These long-term incentives can be further categorized in two parts: non-share based and share-based compensation schemes. The examples for the non-share based would be something like deferred bonuses, where after meeting certain criteria, the employee would receive bonuses or would receive bonuses in tranches. And share-based compensation schemes, which we will be delving into much details today. Employers have been rapidly shifting from a fixed salary model to versatile packages consisting of various incentives, bonuses, and benefits in addition to the base pay. As far as incentives are concerned, share-based compensation schemes and particularly ESOPs happen to be a popular mode of providing long-term incentives to employees. Now, a pertinent question grows and comes to the mind: why ESOPs gain significance? ESOPs or the options, these share-based incentive schemes are issued for various strategic reasons by many listed and unlisted companies. These options are especially given in industries where the retention of key talent is a must, like IT and finance industry, and specifically startups. When startups start their business, they have a lot of cash flow issues. And at the same time, it is a big challenge for the startups to retain top talents. So therefore, ESOPs and these share-based schemes play a very pivot role in shaping out the whole package for the employee in the startups. Apart from this, this economic slowdown has also been a reason where many of the companies revisit to ESOPs, just to reduce the stress on present cash flow and conserve cash resources. In the past, for instance, during the great financial depression of 2008, 2009, various companies, various companies issued new ESOPs, or they repriced their existing ESOPs to retain key talent. And at that time also, there were many companies who were issuing ESOPs for the first time. Even in the current pandemic situation, and cash crunch has likewise made ESOPs an employee retention tool. In India itself, some of the leading startups, like are offering additional stock options to employees in a bid to retain them following broad pay cuts. Many companies have done a mandatory pay cuts. Many have offered voluntary pay cuts. And when they have offered and they have given the option of voluntary pay cuts, they have coupled it with the benefits of more number of ESOPs with better terms than the existing ESOP pools. The startups like Zomato, who is the online food delivery major, Oyo Hotels, Grocery Deliver Grofers, Bounce, and various other startups have already floated ESOPs to employees who have taken voluntary pay cut or whether mandatory pay cuts. Internationally also, companies like Airbnb, which is much in news. Airbnb, because of this COVID-19, has laid off almost about 25% of its employees. However, one amongst the other benefits which it has granted to those which have been laid off is immediate vesting of ESOPs. Now, what are the factors which determine the success rate? So, employees' reaction to ESOPs can be very different, and there are a lot of factors which goes behind it. So, employees' reaction to ESOPs can differ based on the type or size of organization, the industry to which it belongs, volatility of company stock prices, foreseeable future of the business, the vesting period, their own career plans, tendency to value cash over stocks during uncertain times, and so on. So there's so many factors which goes on to decide how the ESOPs, how the employees would react to the ESOPs. Every company is different, every employee is different, but every company has their own vision and mission statements. Keeping your vision and mission statements, a company should draft a comprehensive employee ESOP schemes or an option plan. Now, for instance, ESOP schemes made by market leaders, it would be welcomed by the employees because they are the market leaders, and people have a view that yes, in future also these market leaders will jump back, and it is a short-term crisis. ESOPs are valuable if there is a precedence where people have made money. So, if in some companies, if there is a administrative staff which has made a lot of money, like in Facebook and Infosys, and now if Facebook and Infosys again comes with the ESOP, there's a lot of credibility to those organizations. So people would definitely look forward and will be happy to be a part of such ESOP schemes or the option schemes. It also depends to a great extent on the credibility of the organization, and therefore various factors need to be analyzed before a particular scheme is chosen in the current situation. Even apart from ESOPs, there are various other stock compensation schemes like stock appreciation rights schemes or the phantom stock, restricted stock units, retirement benefit scheme, etc. Then can be floated by a company depending on what suits it the best. Now, moving on, today we will be dealing with the stock-based incentive schemes, but there are certain common terms which are applicable for all these options. First one is a grant of options. You know, these are the options actually when the options have after certain criterias are met or eligibility criteria has been set. After that, the options are granted to an employee. So that is called a grant of an options, and the date on which the options are granted are called the grant date. Some companies have the option, or they make it of grant. There should be a grant price also, but most of the times many companies don't have these grant prices. Vesting of options. Now, once the options have been granted, then there is a period between grant of option and the vesting of the option, when the options actually vest with the employee. And it is the time when the employee becomes entitled to receive a benefit of a grant. Now, vesting period, the law requires that there has to be a minimum vesting period or a waiting period of 1 year from the date of the grant to the vesting of the options. The companies are choose to define vesting requirements. The vesting can be done in tranches. You know, the companies have to be very careful in defining the vesting period. If the vesting period is too long, it becomes unattractive for the employees. If it becomes too short, then the retention period which the employer wants may get reduced. Moving to the next point is exercise of options. After the options have been vested in the employees, then when the employee actually converts those options into the equity shares, or if it is a cashless based system, or when he actually converts those benefits, and case of shares, employee makes an application to the company for issuance of shares, then actually he exercises his options. The exercise price is predetermined. Either a particular price is given, or it is linked to a benchmark, or some formula is being laid out. Companies have freedom to determine exercise price, but those exercise price have to be in conformity with the applicable accounting policies. Difference between the market price on the date of exercise and predetermined exercise price of the share is the effective earning. Priyanka would delve into this aspect on the taxation, how it affects the taxation. So if there is a very high exercise price, again, it becomes unattractive for the employees. You know, sometimes the employers link the exercise price to the last round of funding. And maybe last round of funding would be at a very high level where the employees don't see that much of value. So it becomes very unattractive for the employees. If it becomes very low, the exercise price is very low, the shareholders might reject, especially if the shareholders are big institution. We have seen this case in the past. Most of the option plans floated where a deep discount was given to the employees was largely rejected by institutional investors. In the case of Tech Mahindra, Syngene International, Godrej Agrovet, even in Reliance Industries, though the majority voted in favor, but there were a big chunk of institutional investors who voted against. Next concept is lock-in of shares. Company can specify uh, in their scheme what is the lock-in period. They may choose to have, or they may choose not to have the lock-in period. There is no requirement of lock-in under the law. However, if the shares are issued through a ESPS scheme, which is employee stock purchase schemes, and these shares are issued to the employees simultaneously with the public issue, if it is done at the same price, then there is no requirement of lock-in. However, if the shares under the ESPS scheme are issued at a discount to the employees as compared to what are the price which is issued to the public, then there is a mandatory lock-in period of 1 year. Next slide. Now, I will be quickly touch upon, as we are discussing about this vesting, so I will touch upon the informal guidance by SEBI of March 12, 2019 and February 3, 2020. So, in buyback, a company is prohibited from issuing any shares or securities till closure of buyback is there. So the issue before the SEBI, which was raised by Infosys, was whether grant letters granting ESOPs can be issued during the buyback period. SEBI clarified the grant letters can be issued, but the option should vest or the conversion should happen only after conclusion of buyback offer. The second issue was whether vesting period will be 1 year from the date of grant or from the date being 1 year from closure of the buyback. SEBI clarified that it would be from the date of grant. The buyback regulation also prohibits raising of further capital for 1 year post the buyback period, except for the discharge of subsisting obligations. Of course, recently this 1 year period has been reduced to 6 months by SEBI till December 2020 because of COVID. So the issue was, can the shares be allotted upon exercise of restricted stock units if vesting period of 1 year is completed, but post buyback period of 1 year is not completed? SEBI clarified that issuance of shares pursuant to conversion of restricted stock units would be considered as subsisting obligation, and hence it is allowed. Next slide. Now we will be dealing with the various common kinds of share-based employee benefit schemes. The most common and the most famous one is the employee stock option plans, ESOPs. What are ESOPs? ESOPs are the options given to the employees to purchase or subscribe to the shares of a company at a future date and at a predetermined price. Employee stock purchase schemes. Employee stock purchase schemes are the scheme in which the shares are offered to the employee as a part of the public issue or otherwise. They can happen through trust, where the trust may undertake secondary acquisition. As I earlier said, this ESPS scheme can happen at the same price at which the public issuance is done, or it happens at a price. It can also happen at a discount to the price to which the shares are issued to the public. Next category is stock appreciation rights scheme. The stock appreciation rights scheme is a scheme in which the equivalent of appreciation in a market price of a share over a period of time is offered to the employees. Now there are two ways that these appreciations are offered to the employees. One is the equity settled stock appreciation rights, and other is a cash settled SARs. The cash settled SARs are nothing but very popularly known as phantom stocks or the shadow stocks. Next category is general employee benefit schemes. So general employee benefit schemes are the schemes which deals in shares of the company or of its holding company for a purpose of employee welfare, including healthcare benefits, benefits in case of sickness, accident, death, or scholarship funds, etc. In an informal guidance in JK Paper Limited case, what happened was that JK Paper has created a trust, a private trust. That trust used to hold 5.63% of JK Paper Limited. So JK Paper said that the trust only is holding the shares of JK Paper, but it does not deal in or does not transfer the shares of the company. So whatever dividend the trust receives from its holding, that dividend is being utilized by the trust for the welfare of employees. So the question which JK Paper asked SEBI whether this kind of arrangement, this trust or this scheme would under the ambit of the SEBI SBEV regulations. SEBI said that since the trust is holding the shares of JK Paper Limited, so therefore it is dealing in the shares of the company, and since it is utilizing that, the dividend from those shares for the welfare of the scheme, so all the criteria which are mentioned SBEB are fulfilled, and therefore this trust would form under. Hello.
Sir, you
Hello,
are
can you hear
audible.
me?
Yes, sir, you are audible.
Okay, sorry. Yeah. So SEBI said that yes, you will be this whole scheme would fall under the applicability of SBEB. Only the retirement benefit schemes, they have to be in compliance with the existing retirement benefits laws in India. There are certain benefits of gratuity, or under the EPF Act also, there are certain certain benefits of retirement benefits which has to be complied with. Next slide. Now, the next important aspect is implementation of a scheme. Now, how will this scheme be implemented? The scheme can be implemented either through a direct route, or it can be implemented through a trust route. When a company itself administers the ESOP or any option scheme plan, then it is called a direct route. In the direct route, the employees during the time of exercise of the options make an application to the company, and the company issues fresh shares and allot it to the employees. This is usually a preferred route by private companies and unlisted companies because it is less complex. In trust route, a company set up a separate trust for implementing and administering the scheme. These trusts may acquire shares from secondary market and transfer it to employees. Company may fund the trust for this purpose. Usually, under the Companies Act, it is prohibited for any company to fund for acquisition of its shares or of the holding company. However, an exception has been made in the section 67(3)(b) of the Companies Act for this exception. If the company is going for a trust route, then it has to be decided upfront when you are seeking a shareholders approval. For listed company, the purchase of shares by a trust can happen only through a recognized stock exchange and not through private offers or arrangements. It is also mandatory to implement through trust if a secondary acquisition or a gift is involved. This we have to be clear. If the scheme, or if whatever the process involves that there has to be a secondary acquisition or a gift would be involved in this whole scheme, then the scheme can be implemented only through the trust route. For the unlisted shares, the valuation at which shares are to be purchased by the trust shall be made by a registered valuer. The value of the shares to be purchased, subscribed in aggregate, together with money provided by the company, should not exceed 5% of the paid-up capital and the free reserves. The trust route is more complex to the direct route. However, it is preferred by listed companies because most of the times the trust makes does a secondary acquisition of the stock market without changing the capital base. Who cannot be trustees? The directors, the key management persons, the promoters of the company or of the holding company, subsidiary or associate companies, or their relatives cannot be the trustees of that trust. The person who beneficially holds 10 or more % of the paid up share capital of the company cannot be the trustee of the trust. The whole idea is the trust should be independent as far as possible. Now, I will list down certain common action points for both listed and unlisted companies, which they have to comply while issuing the ESOP plan. The first question which comes to the mind is, to whom can the incentive be issued? So the incentives can be issued to the employees, and the way it is defined is, an employee is someone who's a permanent employee, who is a director, who is a whole-time director of the company or its subsidiary and its holding company in abroad as well as in India. Prior to 2015, associate company was also included. However, it is done away with it. An independent director cannot receive any incentives under these schemes. They cannot be granted any options. A promoter or a person belonging to a promoter group are also not eligible to participate in these incentive schemes. However, for promoting the startup culture, the startups can issue up to 10 years of its incorporation the ESOPs to the promoters as well. A director who himself or through his relative or through any body corporate directly or indirectly holds more than 10% of the outstanding equity share of the company, he is also not eligible for such schemes. Herein also, in the case of startups, startups can issue up to 10 years of its incorporation to directors who hold more than 10% in the company. Every company should have sufficient authorized capital to issue ESOPs, and the articles of association of the company should permit issue of ESOPs. These options, once granted to you, they cannot be transferred. These options cannot be encumbered, pledged, or hypothecated in any manner. Also, right to exercise the option vests only with the employee. However, in the case of a death of an employee during the employment, these options vest in the legal heirs and the nominees of the deceased employee. At the time of resignation termination, options which are not vested as on that day shall expire. Next slide, please. For passing a stock option scheme, a special resolution of the shareholders is required. However, in the case of private companies and specified IFC public companies, ordinary resolution will suffice. So special resolution of shareholders would be applicable in case of the listed companies and unlisted public companies. Separate resolution would be required if the grant is to the employees of subsidiary or holding company. One omnibus resolution would not be sufficient. In a separate resolution, you have to pass it and show it that the grant is being offered to the employees of a holding or a subsidiary company. The grant, if to an identified in any employees in any financial year which exceeds or equals 1% of the issued paid up capital of issued capital at the time of grant of options, then also separate resolution would be required. Additionally, in case of listed companies, if the implementation is through secondary acquisition, then also a separate resolution would require, and that separate resolution or the approval should mention the permitted percentage of secondary acquisition. Secondary acquisition by trust, in case the share capital expands due to capital expansion undertaken by company to maintain prescribed cap, which is 5% under SBEB regulation, of such increased capital also is required to be passed by a separate resolution. As already discussed, that there is a minimum vesting period of 1 year from the grant of options and when the options would vest. However, if the options were granted by a resultant company, in lieu of the options held by employees of merging or amalgamating company, then the period for which those options were held prior to the merger can be adjusted against minimum vesting period. So if prior to the merger, employee was holding was given a grant and it held it for 6 months. So post merger, the minimum period for that option to get vested would be 6 months only. Continuing further, following now in the explanatory statement, which will be issued at the time, which will be annexed to the notice to the shareholders should have the following details so that the shareholders can make an informed decision. And it should be as wide as possible to include all the facets of the scheme. It should include brief description of the scheme, total options, SARs, shares, benefits to be granted, identification of classes of employees entitled to participate, appraisal process to determine eligibility of employees, requirements, period of vesting, maximum vesting period, exercise price, the SAR price or the purchase price or the pricing formula, the exercise period, the process, the lock-in period, if any, mode of implementation and its details, the maximum entitlement of employees and in aggregate, method of valuation of the options and SARs, when can the vested option lapse, with what time can employees exercise vested options in event of proposed termination resignation, statement that the company shall comply with the applicable accounting policies and standards. It should be very exhaustive and it should include every facet of the scheme so that it's become easy as well as it become clear that what is the scheme all about. Till the ESOPs, till these options are not converted into equity shares, till that point of time, the employees do not get any rights of the shareholders. They are not entitled to receive any dividend or get any voting right just because they are holding options. Next point, next slide, please. The board of directors also have to make certain disclosures of the scheme in the board's report. The options, the SARs, etc., that are granted, vested, exercise options, lapse, exercise price have to be mentioned. It also need to be detailed in those disclosures in the board reports about total number of shares arising as a result of exercise, variation of the terms, money realized by exercise, total number of options, SARs, etc. in force, employee-wise details of options granted to specified key employees in terms of designation or amount of grant. Additionally, in case of listed companies, SEBI had come with a circular dated June 16, 2015, which requires the information to be disclosed on company's website and web link that to be provided in the board report, such as relevant disclosures under the applicable accounting standards, disclosures of diluted EPS on issue of shares pursuant to all the schemes covered under the regulation as per applicable accounting standards, scheme-wise disclosures of details related to trust. One trust can have various schemes. There need not to be different trusts for different schemes. So there can be various schemes floated by one trust, and or the scheme-wise disclosure of the details to be mentioned in should also be mentioned in disclosure. Next, next slide. Next slide.
The slide has been moved. I've already.
Okay. So the register of every company is required to maintain a register of options in the form SS6. Various forms which are required to be filed, uploaded when a passing a special resolution is there, MGT 14, when allotment of shares upon exercise pass 3, for variation in terms of the scheme, special resolution should be passed. However, the amendment should not be prejudicial to the interest of options holder. Only the amendment can only happen for the option addition to the
Mr. Yatin, I think we're losing we're frequently losing your voice. So if you can repeat this part again, because you got disconnected in between.
Okay, so okay, on slide 13, okay, So what I was saying is that every company is required to maintain register of the employee stock options to be maintained in Form SH6. For passing a special resolution, MGT 14 is required. For allotment of shares, PAS 3 is required. A scheme can be modified, and it can be modified by special resolution. However, the modification should not be prejudicial to any of the option holders, and the scheme can be modified only to the extent of the options not yet exercised. Lastly, in the case of listed companies, repricing is allowed if scheme rendered unattractive due to fall in the market prices. Now it requests Simran to take it up for the additional action points for the listed companies.
Thank you so much, Mr. Narang, for your valuable inputs. It was beautifully explained. Moving on, as far as listed companies and the schemes, the employee benefit schemes floated by listed companies are concerned, the principal regulations governing such schemes is SEBI Share-Based Employee Benefits Regulations 2014, more popularly known as SBB regulations. These regulations replaced the erstwhile SEBI ESOP and ESPS guidelines. These regulations are very comprehensive. They govern a total of 5 schemes, being ESOPs, ESPS, stock appreciation rights, general employee benefit schemes, and retirement benefit schemes. As far as applicability of the regulations is concerned, Regulation 1, Sub-Regulation 4 provides a 3-point criteria which has to be fulfilled in order for a scheme to fall under the ambit of these regulations. The regulations will be applicable to any company which has listed its shares on a recognized stock exchange, and it has a scheme which, point 1, is for the direct or indirect benefit of the employees. Now, see, as we've already seen that employees is a defined term. So if a person to whom the shares are granted under the scheme does not fall within the ambit of the definition, even if it fulfills the other 2 criteria, it would still fall outside the ambit of the regulations. Point 2 is that the scheme should involve either dealing in or subscribing to or purchasing the securities of the company, whether it be directly or indirectly. So subscribing would be relevant if it's a fresh issue of shares, and purchasing would be relevant if it's existing shares that are traded. The third point is that the scheme should directly or indirectly be either set up or funded or guaranteed or controlled or managed by the company or any other company in its group. So it is not necessary that the company itself has to float the scheme. Any other company in its group may also float it. In fact, it is very common that one group entity floats a scheme wherein shares of another group entity are provided, and it would still fall within the ambit of these regulations. Now, having understood the applicability, we can move ahead So in case of a trust route, for a listed company, the trustees, first of all, the trustees cannot vote in respect of the shares that are held by them. This happens to have its genesis from the idea that a trust should at every point be independent, and there should not be any misuse of the voting rights on the shares that are held by the trust. Now, every listed company has to, on periodic basis, upload its shareholding pattern on the recognized stock exchanges where the shares of the company are listed. And the shareholding has to be divided in certain categories. The shareholding of the trust in this case will fall under the category of non-promoter, non-public shareholding, because of course the trust is neither a promoter and cannot amount to public shareholding either. The trust deed will have to be filed with the stock exchanges. Now the trust deed should have basic points such as what is the name of the trust, the name of the settlor, the object of the trust, also what are the schemes that the trust is going to float, what is the source of funds of the trust, whether it is receiving any loan from the company, and what are the powers of the trustees, who will be the trustees, nationality of the trustees, and so on and so forth. It should have those minimum, at least those minimum disclosures which are provided in the SEBI circular dated June 2015. And in case there is any modification in the trust deed subsequent to its filing with the stock exchanges, it has to be again filed. A modified trust deed will again have to be filed with the stock exchanges. Another important point is that the trust cannot deal in derivatives. In fact, it can undertake only delivery-based transactions for the purposes of secondary acquisition from the stock market. In terms of the limit up to which a trust may purchase shares, it has been provided that the secondary acquisition in a financial year should not exceed 2% of the paid-up equity capital as at the end of previous financial year. And also the total number of shares under secondary acquisition held by the trust at any point of time should not exceed certain limits. Now this limit is a percentage of the paid up equity capital as at the end of financial year, which is immediately prior to the year in which the shareholders' approval was granted. In case of ESOPs, ESPS and stock appreciation rights, the limit is 5%. In case of GEBS and RBS, the limit is 2%. And for all schemes in aggregate, the limit is 5%. Here it is to be remembered that there might be a possibility that a company has multiple trusts and there are multiple schemes, but this limit is at the company level and not at individual trust level. So all the schemes have to be taken together, and it should not breach this limit. Further, okay, so at the outset, whenever a trust acquires shares, it is always backed by grants. That is, a trust would acquire shares pursuant to the grants that the company issues to its employees. But there might be a possibility where a trust is holding certain unappropriated shares which are not backed by grants. And for this, the regulation provides that it should be appropriated within the end of the subsequent financial year. This is basically to ensure that at no point the trust is holding any unappropriated shares. In fact, when the regulations were notified back in 2014, it was provided that if any trust is holding any unappropriated shares, it should appropriate it by issuing it to the employees within a period of 1 year from the notification. And in case it is the trust is unable to do so, it should sell those shares on the secondary market within a period of next 4 years. Now, any trust will have to hold the shares which is acquired through the secondary acquisition for at least a minimum period of 6 months. Again, the only possible outcome of the shares that are acquired by the trust would be its issue to the employees. But there is one case in which the trust may undertake off-market transfer other than for issue to the employees, and that is if it has to participate in buyback or open offers or any delisting offers, or in fact any other exit route which is offered by the company to all the shareholders in general, because trust be having those shares should also have an equal right to participate in any open offer which is available for all the shareholders. Now, the sum and substance of all these restrictions that we've seen on trust so far is to ensure that at no point the trust becomes a mechanism for trading in shares, because it is established for the benefit of the employees to implement the schemes that are for the benefit of the employees. So it should not trade in the shares that are acquired by it. However, there are certain specific scenarios in which even a sale on the secondary market will be allowed. So the first two cases is, of course, for the implementation of the scheme itself, that is cashless exercise of ESOPs and vesting or exercise of stock appreciation rights, where secondary market sale would be allowed. Another scenario is when there is an emergency for implementing the GEBS or RBS schemes, then the trust may sell the shares. However, it will have to record the reasons in writing, and also it should utilize the money within the time which is specified in the scheme or trust deed for this purpose. Another scenario is, of course, as we've already discussed above, if a buyback or an open offer under the takeover regulations or any delisting offer is offered by the company to all of the shareholders in general. Now, if the trust has taken a loan, basically if the company has provided a loan to the trust for the purpose of implementation of the scheme, and if the trust also has certain unappropriated shares which are not appropriated on the time which we've discussed above, then for the purpose of repaying this loan, the trust may sell the shares and repay the loan. And the next scenario would be, of course, in case of winding up of the scheme, the trust may sell the shares and wind up the scheme. And lastly, if the trust has a specific approval from SEBI for this purpose in writing, it will have to apply to SEBI, give the reasons, and also a non-refundable fee of 1 lakh, and SEBI may allow such sale on secondary market on its discretion. Further, every company will have to constitute a compensation committee. Now, this compensation committee will administer the scheme, it will supervise the scheme. It will also determine who will be the eligible employees for the purpose of all the benefits that are supposed to be granted. Generally, the compensation committee will consider factors such as how long has the employee been associated with the company, what is the grade or performance criteria. But in general, always these schemes are offered to a select class of employees whom the company would want to retain. In fact, in most cases, a nomination and remuneration committee is designated as the compensation committee, because the constitution of the compensation committee required under the law is same as required for the NRC under section 178 of the Companies Act 2013. Now, in the trust route, the compensation committee will have to delegate the administration to the trust itself. The CC will formulate detailed terms and conditions of the scheme. These terms would range from the basic term like who are the employees for the purpose of grant of options, for how long will they be holding the options, and so on and so forth. It will also at times specify policies and procedures to ensure that the trust and the company does not prohibit any other SEBI regulations. Say, for instance, SEBI insider trading regulations, or SEBI prohibition of fraudulent and unfair trade practices relating to securities markets. So it can also formulate policies to ensure that none of these other regulations are breached. Now, for example, we can take a few important provisions on which the compensation committee will be required to frame terms and conditions. So in case there is a corporate action, say a rights or a bonus issue or merger, and there is an adjustment to the number of options or SARs or to the exercise price, then the CC will have to provide the procedure for making fair and reasonable adjustment to the entitlement. And while doing this, it will take into consideration certain factors such as that the adjustment should be in a manner that the total value of options granted to the employees remains same after the corporate action also, and the vesting period or the life of the option is as far as possible unaltered, so that it is not unfair on the employees. Another provision is in case of GEBS or RBS schemes, it will have to specify what exactly are the kind of benefits that the company will be offering to the employees. Are these medical benefits, scholarship benefits? What exactly are the kind of benefits? And another provision is that if in case for employees who are on long leave, what exactly will be the granting, the vesting, and the exercise of options or SARs as the case may be. Lastly, it will also have to specify the procedure in case of cashless exercise of options or SARs. Further, so in case of unlisted companies undergoing an IPO, there are certain specific considerations provided in the SBEB regulations. Firstly, the shares that arise after IPO but out of the options granted under the pre-IPO scheme will have to be immediately listed, subject to SEBI ICDR regulations, which is the regulations governing initial public offers, for the public offers, and so on. Over here, it may be relevant to note that under the SEBI ICDR regulations, there is a requirement of lock-in of the pre-issued capital, which is held by persons other than promoters, for a period of 1 year from the date of allotment once the IPO is done. But this lock-in period is not applicable in case of shares which are issued under ESOP schemes. Earlier, the position of former employees of the company was not clear as to whether they would also get benefit of this relaxation, but now the position is very clear, irrespective of whether the employee is a current employee or a former employee. It will not have to it will not be subject to these lock-in restrictions. The second point is that the company should not make any fresh grant under a pre-IPO scheme unless that pre-IPO scheme is in conformity with FBB regulations and it is also ratified by shareholders subsequent to the IPO. And lastly, the company will have to obtain an annual certification from its auditors confirming compliance with the applicable laws, and that certificate will be placed at the AGM. Now, in case of cash settled stock appreciation rights and or popularly known as phantom stock options, there was one issue which came up under the SEBI SBB regulations, and SEBI provided some guidance on this in two of its informal guidances. So the issue was whether these phantom stock options would in fact be covered under the SBB regulations or not, because there is no actual issue of shares. What generally happens in a phantom stock option is that the SAR is granted and there is a grant price and there's a vesting period, and when the vesting period is complete on the date of settlement of SAR, whatever is the market price of the share, and the difference between the market price of the share and the grant price will be payable to the employee, as in the appreciation will be payable to employee. It could either be equity settled, it could be cash settled also, but if in case it is cash settled, there is no actual purchase or selling of shares, then whether SBB regulation would apply or not. So in Mindtree Limited and also in Saregama Limited, wherein the issue was whether, wherein in these cases, the companies issued SAR units, notional SAR units, having which were linked to the equity shares of the company, and the grantees were entitled to receive cash payment for appreciation in share price, and no fresh issue of shares was contemplated. So in both these schemes, SEBI effectively opined that since one of the applicability criteria mentioned in Regulation 1, Sub-Regulation 4, as we discussed before, is for the scheme to actually involve dealing in or subscribing or purchasing securities of the company, cash settled SARs were not governed by SEBI SBB regulations. So as we've already discussed that all the three criteria have to be fulfilled in order for a scheme to fall within the ambit of the regulations. And since this one criteria was not fulfilled, SEBI opined this way. However, it has to always be remembered that these informal guidance letters only have a persuasive value. And in fact, in the informal guidance scheme, it is specifically stated that it should not be conclusive of determination of any question or of law or fact by SEBI. Hence, as a matter of caution, if any company wishes to rely on these informal guidance letters, it should at least ensure that the facts of their scheme are similar, in fact, substantially similar to the facts in the schemes in these informal guidance, and only then tread this path. Further, in furtherance to the previous issue, there is another issue as to what is the position of cash settled SARs which are implemented through trust route and they involve secondary market acquisition. For better understanding, let's take an example. So in case a company formulates a SAR scheme and each SAR unit derives value from one equity share, then the company on-lends to the trust for implementing the scheme. When the SARs are granted, the trust acquires requisite shares through secondary market acquisition by utilizing the loan amount received from the company. Then on the date of settlement, the trust sells the shares and the difference between the market price on the date of redemption and the grant price will be paid to the employees in cash. So over here, even though ultimately the SAR is cash settled, there is secondary market purchase involved and hence there is an actual dealing in shares involved. Hence, even though cash settled, it seems that SBB regulations would apply in this case because it satisfies all the three criteria mentioned in the regulations for applicability. With this, I would now like Mr. Narang to throw some light on insider trading vis-a-vis ESOPs. Over to you, sir.
Thank you, Simran. Thank you for your inputs. Now, in SEBI Prohibition of Insider Trading regulations, The question is, the designated person cannot execute a contra trade for at least 6 months. Now, will this apply on exercise of ESOPs and the sale of sale shares so acquired? So SEBI clarified in guidance note in August 2015 itself that exercise of ESOP is not trading, except for the purpose of Chapter 3, which is the disclosure requirement for insiders. Hence, contra trade restrictions is not applicable. So let's take a case. Suppose a person sells shares and within 6 months purchases shares under ESOP. The issue is whether the exercise of ESOPs will attract CTR. The legal position is no, but any purchases over and above the exercise of ESOPs will attract CTR. Suppose now in the next scenario, if a person acquires shares under ESOP and within 6 months sells or pledge those shares, the issue is whether sale or pledge of shares will be a contra trade with respect to ESOPs. The legal position is no. However, the sale will be subject to all other provisions of the insider trading regulation. Same position was even in the case of trust route. SEBI clarified it in the KPIT Technologies case. Next, please. In November 4, 2019, the SEBI clarified through FAQs. SEBI, not the question whether requirement of pre-clearance of trades of insiders is applicable for exercise of ESOPs. So SEBI referred to clause 4.3b of Schedule B of the PIT regulations. SEBI said that these regulations effectively allows designated person and the immediate relatives to trade in securities even when the trading window is closed in case of transactions undertaken in accordance with respective SEBI regulations, such as acquisition by conversion of warrants, debentures, subscribing to rights for the public issues, preferential allotment, tendering of shares in a buyback or open offer or delisting offer. SEBI said that exercise of ESOPs will be covered under clause 4.3b of the Schedule B as they are issued under SBEB regulations. Hence, no pre-clearance required for exercise of options. However, for sale of shares issued pursuant to ESOPs is not covered in the above clause. Therefore, the pre-clearance is required. In December 2018, SEBI made an amendment to expressly allow exercise of ESOPs by employees when in possession of unpublished price-sensitive information. However, the exercise price should be predetermined and it should be in compliance with applicable regulations. Now, moving on to FEMA implications in ESOPs. There are two, so here we will be dealing with the FEMA non-debt instrument rules 2019. It is when a non-resident employee acquires certain options in the Indian company, then these regulations would be applicable. And when an Indian employee acquires the shares of a foreign company, then the ODI regulations would be applicable. We would deal with them one by one. So first, the FEMA non-debt instrumental rules 2019. As per the rules, ESOPs may be issued to non-resident employees subject to the following conditions. The first and the foremost condition is that the scheme has to be drawn under the Companies Act in the case of private and unlisted companies, and in the case of listed companies, the scheme has to be in compliance with SEBI SBEB regulations. The sectoral cap which is applicable to the company must be complied with. Prior government approval would be required if investment by person resident outside India is under approval route. In the rules, it was also very clear that the prior government approval is required if the ESOPs are issued to citizens of Pakistan and Bangladesh. However, with this press note 3 of 2020, which has put a restriction on FDI from an entity of a country which shares land border with India, or where the beneficial owner of investment into India is situated in or is a citizen of any such country, can invest only under government route. So it is an open issue whether ESOPs granted to a citizen of these countries which share land border would also require prior government approval or not. We'll wait for some more clarification in this respect. If ESOP was issued when an employee was an Indian resident, the acquired shares shall be held on non-repatriation basis if the employees move ahead after it exercise. So in FEMA mode of payment and reporting of non-debt instrument regulation 2019, there are various forms filings which have to be done. Form ESOP needs to be filed within 30 days from the date of issue of options. Form FCGPR needs to be filed within 30 days from the date of allotment of shares, when the shares are actually allotted after the options are exercised. Form DRR to be filed in case ESOPs are linked to ADRs and GDRs. Now next is the FEMA implications under ODI. Under the Overseas Direct Investment Regulation, general permission is granted to a person resident in India to acquire shares under cashless ESOPs issued by a foreign company, provided it does not involve any remittance from India. Now, to purchase equity shares offered by a foreign company under its ESOP scheme by eligible persons, and the eligible persons would be if he is an employee or a director of an Indian office or a branch of a foreign company, or of a subsidiary in India of a foreign company, or an Indian company in which foreign equity holding is there, then authorized dealer bank can allow remittances for purchase of shares irrespective of the method of operationalization of the scheme, whether it is direct or through trust or any special purpose vehicle, provided, however, the shares are offered by the company globally on a uniform basis, and an annual return is filed by Indian company through authorized dealer bank giving details of remittances and beneficiaries. In case of sale of acquired shares, the proceeds should be repatriated immediately, but not later than 90 days from the day of sale. Repurchase of shares by foreign company is allowed if shares were issued in accordance with the rules, regulations framed under FEMA. Repurchase is in terms of the initial offer document. So whatever repurchase has happened, it was contemplated, applications were contemplated in the scheme itself in the offer document. And an annual return is filed through authorized dealer bank giving details of remittances and beneficiaries, etc. With this, now I hand over the baton to Priyanka to deal with the taxation aspects of these schemes, these options. Priyanka, over to you now.
Hi, everybody. After looking at the non-tax regulatory aspects, we move on to how is the taxation of ESOPs being dealt with under the Indian tax laws. The ESOP taxation has actually evolved over the last 2 decades. You know, we had the phase where there were uncodified tax provisions and the benefits were available on general taxation principles. Then we gradually moved to a period during which ESOPs were incentivized and were taxed only at the time when there was a final exit or a sale. Then we had an intermediate stage where ESOPs were subjected to FBT tax. And after its abolishment, we have the present provisions of ESOP taxation, which have, I think, been here since 2010. So the taxation of ESOPs actually vary depending on the type of ESOPs also, because it depends whether there is actually an allotment of shares or is it merely cash payment which would be done to the employees at the time of exercise. Coming to the taxability in the hands of the employees who are being vested with the ESOP options. Now, under income tax, the income is generally defined under Section 224 to include a benefit or perquisite or concession. Now, if the benefit or perquisite is arising in the course of employment, it is taxed under the head salaries, while if the same is arising from exercise of business or profession, it will be taxed as business income. Now we are dealing with mostly where ESOPs have been granted to the employees and there is an employer-employee relationship. So those would be governed by the sections 17, which deal with the perquisites in the hands of an employee. More specifically, section 17(2)(6) of the Income Tax Act provides that any compensation which has been granted by way of stock options by an employer to an employee shall be treated as a perquisite and it shall form part of its taxable salary income. Now, what will be the value of the perquisite? That should be the difference between the fair market value of that security or stock on the date when the option is exercised and reduced by the amount which has been recovered from the employee. So this is the first stage of taxation of an ESOP. That is when the employee is exercising that option. The taxation is on the exercise price minus whatever has been is the difference between the exercise price minus the fair market value of that stock as on the date of exercise is what is taxed as a perquisite in the hands of employee. Now we will see later how this also acts as a disadvantage in case of a lot of companies which are especially maybe bootstrap startups. But before coming to that, we can deal with what happens later. So after you have exercised the stock options, if you have received any dividend from the company, now it gets taxed in the hands of the employee. Any further exit, any sale, buyback which happens of the ESOP or the stock will be taxed again further in the hands of the employee. If the employee has made the sale in a normal course, that will gains would arise as capital gains and it would be long term or short term depending on the period of holding. Now the period of holding shall be calculated from the date of allotment of such shares. Now since we have seen that the tax has already been levied at the time when the exercise has happened, that is the cost which should be taken for the purpose of computing the capital gain so that we avoid a double taxation. This is a kind of a beneficial provision which is given in case of ESOPs which are granted to employees. Now we also saw we only spoke about the taxation of a salaried employee. In case if ESOPs or equity shares are allotted or given to consultants or advisors who are engaged in business or profession, then that perquisite element will get taxed as profits and gains of business or profession under section 28(4) also. In other cases, it will get taxed as income from other sources under section 224(4) of the Income Tax Act. Now, in case if there is a further sale, in case where it's a non-employee and a non-salaried ESOP, it will be similarly taxed as capital gains in the hands of the person who is making the sale, depending again on the period of holding. Now, there can also be a situation where instead of making a third-party sale, there is an offer for buyback of these ESOP by the companies. In that case, we have the buyback taxation rules which will apply. Section 115 QA of the Income Tax Act deals with buyback. Now it applies to both listed companies and as well as unlisted companies. So as per the buyback taxation, the distributed income which is paid to the shareholder will be charged to tax at the rate of 20% plus applicable surcharge and cess. The taxation would be borne by the company and not by the shareholder, which here is the employee. The distributed income will be calculated as the buyback price minus the amount which has been received by the company for issue of shares. But in case of ESOP, the amount received by the company in case of issue of shares shall be taken as the fair market value which was used for calculating the perquisite when the employee exercised that option. Now, what happens in case of the ESOP options also provide some right to the assessee, to the taxpayer, to not exercise the ESOP, but to make a transfer of that options in favor of a third person. Now, I think that phenomena is not prevalent in India, but we have seen that the tribunal has taken a view that if the ESOP options are transferred before the exercise date, that gives rise to a capital gain. And why they say so is because they say that ESOP options provide valuable right to the assessee to exercise the shares, to have the allotment of shares, and hence that right in itself is a capital asset held by the assessee right from the date of grant. Now, if the assessee is transferring that option or that grant itself, capital gains will have to be levied, and in case if it is more than 3 years, it will be taxed as long-term capital gains, and in other cases, it will be a short-term capital gain. Now, that was when the period of holding was 3 years. Now it's been reduced to 2 years. So accordingly, the taxation scheme would work. That in the hands of the employer who's floating the ESOP scheme, he is under an obligation to withhold taxes at the time of payment of any income in the form of salary. The rate of tax is determined at the average income tax computed on the basis of rate in force for that particular financial year. And when they are computing the income under salary, the value of purchases in the year when the options are exercised will have to be calculated and included as part of the total salary income, and there have to be a withholding tax on it in the hands of the employer. Now, I had initially mentioned how the exercise tax is a disadvantage. Now, when the employee is actually exercising the stock option, he is shelling out tax by way of this withholding tax. However, he is not getting any cash inflow in return. So there is a bit of cash mismanagement because of this taxation. And in case where the employees are facing liquidity crunch, it is really becomes a big issue to deal with when you have to pay tax on a notional income and without a corresponding cash inflow, and you don't even know whether that cash which you have shelled out will actually be recoverable or not, because the value of the shares may go either ways. Especially in case of startups, if the valuation of the shares have gone really low, you may end up paying more tax than what you actually is the value of the shares. Now, this is one aspect which has always been voiced by the companies, by the startups recently to the Ministry of Finance, and given a proposal that the taxation at the time of exercise should be done away with, and there should be only one simple taxation at the time of exit or sale. Uh, so when the employer is giving these ESOP options to the employee, there is a cost element associated to it. The cost is basically the amount of money which the employer is foregoing by not recovering that amount of money which he would have recovered had a third party shareholder subscribed to the shares. So the discount on the issue of shares is basically the cost. Now, employers are definitely eligible to claim this deduction as part of business expenditure, because it is fairly settled that any expenses for the welfare of employees is allowable as a business deduction. But the issue which arises is that what is the amount which is allowable as a deduction and when is it allowable? So the position as it stands is that the Bangalore bench of the tribunal, it was a special bench decision in the case of Biocon Limited, and I think is fairly popular and a landmark judgment on this issue, which held that the employer is eligible to claim deduction of the difference between the fair market value of the shares and the amount received from the employee at the time of exercise of the option as a business deduction, and this can be spread over the vesting period. So in terms of accounting also, this deduction or this discount is allowable as a deduction, business deduction in the profit and loss account over the vesting period. Similarly, on similar lines, the Bangalore bench has held it to be an allowable deduction. Interestingly, that this special bench of the decision has also been followed by various benches of the tribunal across India on this issue. But recently, the Bombay High Court, in case of Goldman Sachs, has actually admitted the revenue's appeal on the issue whether this amount of deduction, because it is in some way a notional deduction, whether this is actually eligible to the employer or not. The revenue appeal has been admitted, which does give an indication that the question of law is still open. To my knowledge, the matter is yet not been adjudicated by the Honorable High Court and is pending decision. So we need to see whether this would hold true for the times to come. Uh, but of course, even if it is being claimed as a deduction, it is always subject to revision at the time of exercise. So if for example, the employee does not exercise that option, of course, this is an excess deduction which you may have claimed. So like any other liability which you write off or which is not recoverable, it can be subject to adjustment to tax in the year of exercise. Uh, now, what happens in case if the stock options of a parent company are granted to an Indian subsidiary? So this is practically quite common. Even in that case, it is fairly settled by the by a lot of tribunals benches that this income is also part of a salary income, even if it may not have come from the employer directly, and is taxed in the hands of the employee as a regular ESOP perquisite. The Indian subsidiary is generally held liable to withhold taxes on such income, and the Indian subsidiary can also claim the deduction of such expenses, provided that it reimburses that discount cost to the parent company under an agreement between the company, because it can also give rise to another host of transfer pricing issues. So this is regarding the basic structure of ESOP taxation in India. Now, ESOP policy is gaining a lot of momentum, especially because it's being very popular with the startups. Now, over the past 3 months, we have seen that a lot of startups, be it Oyo or Zomato or Bounce or Grofers, have been hit by the pandemic. And I think Grofers has only taken a temporary hit. But in lieu of the cash crunch, they have thrust ESOPs upon employees whose salaries were cut. In fact, we have read reports in the newspaper that even those who were fired, the employees and companies like Swiggy and Ola have offered accelerated vesting options of ESOPs. So basically, we see the trend that the grant of ESOPs is to conserve cash, because what you are giving as a compensation is of course something which is luring to the employees, but there is no cash outflow since revenues have collapsed. So having this a new phenomena in our in country, because in US and China, I think this was always popular with the startups, but it has catching hold recently in India. So given this, the startup ESOPs, which is I think now around $5 billion in India, has found their first ever mention in the budget 2020, which was recently passed in Feb 20. Uh, According to the budget amendments, the startups, the finance ministry has recognized that startups are emerging as engines of growth for our economy. And we have seen the Startup India policy and the other tax exemptions which have been showered upon. And the government has been taking several measures to handhold them and support their growth. Now, during the formative years, the startups usually use ESOPs to attract and retain highly talented employees, and which they otherwise cannot do, given that they cannot match up the cost of the industry. So, ESOP is a significant component of compensation for startups, and currently, as we have seen, ESOPs are taxed at the time of exercise, which leads to a cash flow problem, and also that it forces you to hold to the shares for a long term, because you want to gain back that money which you have at least paid for that exercise price. So in order to give a boost, the burden of taxation of the employees in case of startup has been deferred, and the tax payment will now happen after either end of 5 years or till the employee leaves the company, or when they sell the shares, whichever is the earliest of the three. So there is, the taxation has not totally been done away with, it's only been deferred for a certain number of years and for a certain number of events, so as to give certain breathing space to the employees of startups who may not otherwise have that cash to shell out for the exercise price. The other point in case of a startup taxation is also that it's interesting to note that this amendment has brought a lot of cheer and a lot of attention, but I think it is only with time to see whether it is actually giving rise to any benefit. And why I say so is because we see that the Department of DPIIT has recognized around 33 startups till date, but the tax benefits are relevant only for 250 of them. And for 250 startups, so basically this amendment is applicable for only the 200 to 250 of those startups who even want to avail that ESOP scheme. The dichotomy is that the rest of the startups will still face the normal structure of taxation, where tax has to be paid at the time of exercise. Probably this could give rise to more tax efficient structuring for ESOPs, because if you could manage the cash outflow by not paying tax at the time of exercise, will act as a big boon to the startups. So by this I mean that instead of the plain vanilla ESOP schemes, which are very common in India, startups could look to adopting the stock appreciation plans, or what we popularly call as the phantom plans, wherein there is no stock transfer, so it also helps in not diluting your shareholding or your ownership, which may be a lot of concern for the promoters and the founders. But it gives you that cash only at the time of and after the vesting period or on the happening of a certain event. And the tax liability also arises when there is actually a cash coming into the employee. So in case of stock appreciation rights, the income will only be taxed when cash is actually paid, so at the time of redemption of those stock appreciation rights. And generally we have seen that the stock appreciation rights are not very popular in India. Maybe the reason is it is not very well known, or a lot is not talked about it in India. But countries such as China, Singapore, or USA have a lot of popularity for phantom stocks. So in order to manage your liquidity generation and to defer your payment of taxes, maybe one of those options can be explored. Uh, that apart, I think this is primarily what is about the ESOP taxation scheme in India. And I think I can, since it's about time, I will hand it over to Parth and Simran for taking the questions from the live audience.
Thank you so much, Ms. Priyanka. Now we would proceed towards taking some questions from the audience. So I can see there are a number of questions which have been posted by the audience. So we'll try and take as many questions as possible. So the first question is, what compliances would be required to be done by an Indian company if an employee of the Indian company, which is a subsidiary of the foreign company, is granted phantom stocks linked to shares of foreign company, and the cash is finally settled by Indian company?
So I'll try to answer. So if I correctly get it, so what the question it says is that the phantom stocks are linked to the shares of the foreign company. However, at the time of the final payout is done by the Indian company to which the employee belongs. So though, so in this question, though though the phantom stocks looks like it is belonging to a foreign company, but the final settlement would be done by the Indian company as a bonus or perquisite. So in this manner, in this situation, I feel that uh, the company would be required, the Indian company, at the time of passing this scheme or adhering to the scheme of the parent, will have to pass a board resolution in which it would accept uh, these plan. It in the scheme also, or in the board resolution, it will approve the employee who is eligible in that part of the scheme, and various other terms and conditions and the requirements, they will be there. From the company perspective, it is the board resolution that should be sufficient in this case. And I think there would be a deal of adherence that employee, the company, and the foreign company would part. A stamp duty may be leviable on that deed of adherence. I think these are the basic in terms of phantom stocks, which will be settled by the Indian company with its own employee.
Okay. So the other question is, are SBEV regulations applicable to debt listed companies?
Simran, I think you can take this. You want to take it up?
Simran, you're on mute.
I'm so sorry. So I think what the participant is trying to ask is whether if the only the debt instruments are listed on the stock exchange and not the shares. Obviously, if the shares are listed, SBB regulations would apply. So the word share has been defined in the regulations, and it means equity shares or securities which are convertible into equity shares, and also of course depository receipts like ADR and GDR, which have their underlying equity shares. So in case of pure debt instruments, I don't think SBB regulations would apply if you go by strict reading of the act. Of course, that does not mean that the debt listed companies would not have to comply with any other law. The Companies Act would definitely apply to the schemes floated by such companies. Yeah.
Yeah. The question I think is directed to Ms. Priyanka because it's a text question. So the question is there a valuation mechanism provided under Income Tax Act for calculating the fair market value of ESOPs?
Yes. So, so when you have to calculate the fair market value of ESOPs is when it is taxed as perquisite at the time of exercise. So that fair market valuation rules have also been prescribed under the income tax rules, Rule 38, which provides that in case of the shares through which you are exercising the ESOP are listed on a recognized stock exchange, the fair market value shall be the average of the opening and the closing price as on the date of exercise. And in case if the shares are not listed on the recognized stock exchange, the fair market value shall be the value as determined by a merchant banker. And when I'm talking about shares not being listed on the stock exchange, I am also including foreign entity shares because those are considered as unlisted shares in India. So if a subsidiary employees of subsidiary are being granted stock options of a parent company which is not of a resident in India, the valuation mechanism will be as may be determined by a merchant banker. The merchant banker has to be a SEBI registered merchant banker in India.
The next question is, what is the use of floating a cash settled SAR if employee does not get shares?
This cash settled SAR, as Priyanka also said, it is very common in China and other countries, and it is gaining momentum in India. Though they are not getting, perquisites, they are not getting shares, but they are getting the value of whatever appreciation the employees would get. It is a win-win for both the employer as well as the employee. In employer, if you think from the perspective of the employer or the promoters or the shareholders, in that case, the capital base is not getting reduced. They don't have to issue shares, or there are chances, they may transfer shares and give control. So in that perspective, perspective, it is very good for the employer. From employee perspective, if you see also, his contribution is, or his the bonuses or the perquisite, it is linked to the appreciation of the value of the share. So he is involved into the company, and he gets money, and then he's taxed as a, it is a part of a bonus. So this is how he gets the value, the employee gets a value, and the employer also gets a control. It's a win-win kind of a situation for both.
Uh, so the other question is again a text question. I think this is for Ms. Priyanka. Are ESOPs offered by holding company to the employees of subsidiary company taxable as salary?
Okay, yeah. So I think I dealt with this when I was speaking, but yes, if the ESOPs are offered by holding company to employees of subsidiary company, and I'm assuming they're talking about cross-border transactions, then even otherwise, even if both are resident or one of them is a non-resident, yes, the benefit arising to the employees of Indian subsidiary will be taxed as salaries in the hands of Indian employees, and this has now been fairly settled by a lot of judgments, starting from Microsoft Corporation USA, which was the first judgment on this issue. But this has been consistently followed, and even in fact, the Supreme Court also has held that employer-employee relationship is not necessary for an income to be taxed under the head salaries under ESOP. So, if the reward is given for services rendered, in that case it will still be taxed as salary, but due to practical challenges it is seen that the parent company is not in a position to withhold the taxes, which otherwise is subject to withholding taxes. So the Indian subsidiary will withhold the taxes, and the parent company, recovers that cost by way of cross charge from the subsidiary.
Okay. So other question is, for listed company, is it necessary to create a trust for ESOP?
Simran, you can take this up.
Simran, you're on mute again.
I'm so sorry. It is not necessary at all for a listed company to mandatorily create a trust. It can go under the direct route also. In fact, a lot of companies go under the direct route. However, of course, there are two conditions. If there is secondary acquisition or gift involved, then a trust would be mandatorily required. But direct issue is very much possible even for a listed company.
Okay, so there's one more question, which is a very interesting question. Can I immediately sell off my shares issued under ESOPs?
Okay, when ESOP means when the shares are allotted to you after you exercise. So in law there is no requirement of lock-in per se as far as ESOPs are concerned. So if the company has not specified a lock-in period, then you can definitely do that. However, if the company has specified a lock-in period, then you have to abide by that. So you have to see the terms and conditions. In the case of employee stock purchase schemes, in case of if the shares are allotted pursuant to ESPS, then there is a lock-in of 1 year. When the shares are allotted, if the shares are allotted at the time of public issue and the shares allotted to employees are at a discount. So if there is no discount to the price to which the shares are allotted to employees, then there is no requirement of lock-in period.
Thank you. So the other question is very low EP. Why rejection? Only this much is written in the question. So
Low EV.
very low
EP.
EP.
Okay. And
Why
exercise
rejection?
price. Okay. Okay. I think it is referred to the point which I mentioned, that if the exercise price is low, then the institutional investors will reject, and they have done in the past also in the various cases which we have seen. I think institutional investors invest at a certain price, and they have certain returns in their mind. So they don't want, a deep discount to be granted to someone else. They are concerned with their mullahs. So they want to take that, and any kind of deep discount to any person they don't want to get in. I think that is the prominent reason where the EVs reject the deep discounts being offered to the employees under the ESOP. Other than that, I think if there are minor discounts, I think that is fine. But if there are deep discounts, they are definitely concerned. Therefore, they would reject it.
Okay. So one more question we'll take, because I think we're already exceeding our time limit now. So this is the last question that we'll take. Is voting right necessary to be given to employees who are being offered options?
Oh, not at all. In fact, that is what I said, that unless the options are exercised and the shares are allotted, till that time, no rights of a shareholders are being granted. So once he becomes he's been allotted, and employees allotted a share, then only he becomes a shareholder and he gets a right of voting and dividend, etc. But till the options are not converted, he will not get any rights.
Very well explained. Now I would request Simran to please come on the screen and put the closing remarks. Simran, over to you.
So thank you, Parth. First of all, I would like to extend a big thank you to our panelists for their very crisp yet comprehensive insights on various legal, FEMA and tax issues, and also how ESOPs can act as a retention tool for companies. Thank you so much, sir. Thank you so much, ma'am. I would also like to thank our participants for their patient listening. If you still have any queries, you can feel free to reach out to us and we will definitely get back to you. And the participants can also check out our upcoming webinars. They are posted on our LinkedIn profile, Vaish Associates Advocates, and we will be happy to address you all in the forthcoming webinars as well. So with this, I would like to end the session, and I hope you all have a good evening.
Yeah,
Thank
thanks to
Thank you.
Simran also.
Parth, yeah, thank you, Simran. Parth, are there more questions then?
Sir, there are almost 22 questions I can see which are unanswered.
Okay, I think we can then separately mail them the reply to the queries.
Sure. Yes, sir.
Yeah. Thank you very much. Thank you all. Thank you.
Thank you. Bye-bye.
Bye.